But that generally shouldn't be the main concern.
It shouldn't be the main intent in the sense.
That shouldn't be. Yeah.
Okay. It's just that it became popular.
It became popular because ABSD is very high. So whatever device that people can get their hands on, they will want to try it.
Alright, welcome back to our So Far So Good Season 2, and we're back with a brand new season, talking to different partners, different vendors, and of course different real estate experts that are related to the real estate industry. We hope that this season 2 right here in our So Far So Good series is going to add value to you, especially in your decision of buying, selling, investing in real estate. And do catch us on Spotify. We're also on Apple Podcasts as well as our YouTube channel. This is also going to be uploaded on Facebook and Instagram via IGTV and Facebook video as well. So today we have Mr. Ivan Lee, a partner at Tito Isaac and Company. He's also the head of real estate practice, and today we're going to chat a lot about conveyancing and things that are related to the buying and selling of real estate in Singapore, especially when the market is so hot right now in the year 2021. Ivan, good to have you with us.
Hi, thank you. Welcome.
Thanks for making time and also appearing on season number 2.
Thank you for inviting me.
No problem. How have you been for year 2021?
I think 2021 has been a good year. Quite a number of transactions, I believe, in real estate. So after the agents starts doing all their work, then it comes to the lawyers. So we are also quite busy lah.
Okay,
Yeah.
great. Maybe share with our audience a brief introduction. When did you start practicing law?
I actually admitted to bar in 2016, so just about 5 years ago. Graduated from SMU. Admitted to bar with the current law firm, Tito Isaac and Company, LLP, as an associate. Then I worked all my way up. So currently a partner and head of real estate.
I think you must be a very fast high flyer in the firm because you are very young, and then now you are head of conveyancing, I believe.
Yes,
right. In the world of conveyancing, you definitely have met a lot of different kinds of cases, especially when it comes to purchasing, selling.
Correct.
And yeah, we're gonna prick on your brain today because we deal with a lot of investing and purchase, and we go through a lot of options day in and day out.
Right.
But definitely, I think your advice to our audience is coming straight from a conveyancing lawyer, especially with your years of experience. So maybe we're gonna do a few different kinds of questions today. How about we start off with the part on inheritance, because we have recently a couple of questions coming from a few of our clients, like they're asking, they inherited a property from their parents after the parents passed away and things like that. They are concerned about the manner of holding, like are they allowed to hold or do they have to sell? And also, is there any stamp duty that's involved? Because based on our little bit of research, we know that this thing called the inheritance tax has been abolished many years back. So, but the presence of stamp duty will still apply for maybe their future purchase, right? If a couple is already owning a HDB property, and maybe they have already fulfilled the MOP period.
Okay.
And then when their parents pass away, and the parents actually want to hand over to them via their will the full ownership of the HDB flat. What happens in this instance?
In this instance, because it's already after MOP, so most of the time it shouldn't be an issue for the owners to be able to take over a second property. So the regulations are quite similar. So I would assume that the second property is a private property lah.
Okay, if it's a HDB property.
If it's a HDB property, then there are actually two ways to look at this thing. So general rule is that you cannot hold two HDB properties at the same time. That much is clear, unless the inherited property has been purchased by the parents before a certain date, right? So if it has been purchased before a certain date, then that property can actually continue to be held for private property and HDB property, right? But when there are two HDB properties, generally one of it will have to be sold lah. Yeah, so that one is actually quite clear. So the scenario can be quite different depending on whether you own a HDB property first or you own a private residential property first, and whether the inherited property is private residential or it's a HDB property. Yeah, so if it's actually both HDB properties, then I think the answer is generally quite straightforward. That you will have to either sell one of it, or if one of it is still within MOP, then you
Very
will
clear cut, you have
probably have to return it back to HDB lah.
Mm.
Yeah, for that purposes.
Right.
Mm.
What if it's the couple is already owning a private property?
Mm.
Parents so-called will to them a private property as well.
Okay.
Yeah. So will there be stamp duty involved?
For transmission or transfer of property by will, whether it's actually by will or intestate, in the sense that there's no will but it complies with the Intestate Succession Act. So stamp duty wise, generally I think IRAS has been quite clear on this point. There's no stamp duties that's required for this particular transfer. Yeah, but it would also mean that this remission or this waiver of stamp duty, so-called, is only applicable to this current transfer pursuant to the will, right? So you must comply strictly with the will. If you want to deviate from the will, for example, A wills it to B and C, right? But maybe C is a brother who doesn't want the property, and it's quite common. So he wants to give it to somebody else, maybe another family member, or the children maybe. So now they want to transfer, instead of giving it to B and C, to give it to B and D instead, right? Then because the transfer to B is pursuant to the will, there is no stamp duty for that share of the property, right? But since now the will states to give the other share to C, but C doesn't want it, it wants to direct it to D instead, then that share of the transfer to D, whether or not through C, when it's being effected, will be subject to stamp duty. Yeah,
because it's like another transaction.
Either it can be considered as another transaction, or sometimes what we will do is, instead of having to transfer to C then to D, sometimes we will do what we call deed of disclaimer lah. That means D will just disclaim the property, and then it will get transferred to somebody that he appoints. So it can be done directly from the estate to party D, but the situation is that as long as it is not strictly in compliance with what the will says, then that will become a transaction that requires payment of stamp duties. Yeah.
Great. I think great illustration. And of course, I think when this inherited property is being taken over, this will definitely add to the property count that this couple is holding. So it will be counted as a second property. And then although the inherited property has no stamp duty involved, but the moment they want to purchase a third property, definitely they will be counted as having the third property ABSD per se.
Correct.
Right.
Yeah.
So far, what has been like the most complicated case that you have ever seen?
From inherited property, the complication usually from a conveyancing perspective is where the will is not clear. Yeah, so all these things can actually be prevented, because how should I describe this area of legal work, right? Essentially, it's actually to assist the clients to perform the title transfer, right? So the title transfer is a separate matter in terms of in law, as compared to the contract itself, or to the drafting of the will, or to the court order. So things like the will or the court order, or the contract, right, essentially tells you what you need to do, right? But then what the conveyancing transaction is essentially is to assist the clients to comply with the order, and to ensure that what they have been asked to do is done legally, right? So when the will is unclear, it becomes very difficult to follow and to know exactly what needs to be performed, right? Because wills can become complicated. It becomes very unclear whether the property is to be held in succession, for example. Certain clauses, when they are not very clear, to say that the property is to be gifted to the son, but the spouse, or that means the mother lah, will have a right to stay in the property until she passes on, and without her consent they cannot sell the property. Right. So we will need to actually, if there's no dispute, then of course we will have to look at it, and then we will of course speak to the administrator, or to the executor, to see what is the actual intention of the deceased lah, when he actually drafted the will, and we try to do the transfer accordingly. So when there's no dispute, it's more straightforward. Yeah, but some of these things, like the one that I just previously mentioned, essentially is because it's complicated because in Singapore it's very rare for that to happen. There's this thing called a life interest. Right, a life interest essentially is that I can give a property to A for the duration of A's life, and then after A passes on, the property then goes to B.
Oh.
Right, so this is something that was developed from olden days England time lah. Where they try to keep the property within the same family. Right, so but this is very rarely done in Singapore.
Okay.
But
is it because a lot of people don't know of its existence?
It's also true that most people don't know of its existence, but it's also because it will lower the value of the property, because when the life interest holder is holding the property, essentially the life interest holder only has a property or right against the property for the period of his life.
Provided it's like a freehold property.
Generally, for the period of his life.
So he cannot sell it away.
It's very hard to sell because he then only has the right to sell for that period of his life, which means that nobody knows when he's going to.
But is he allowed to sell in the first place? Because
essentially,
or there will be a caveat being lodged against that property.
It's almost quite impossible to sell it.
Okay.
Because there is almost no marketability. Because the first person that is holding the shorter term and not the remaining period, really has like a lease over that property lah, which generally has no value, right? But the remaining person, if he's not willing to also sell his share, that means to sell both of it together, the buyer essentially is only buying for an unknown period of time. So essentially there's no marketability. So which is why it's not actually done in Singapore most of the time. But then it appears more frequently when it's in a will situation. So sometimes different kind of drafting using different kind of language, we are not sure whether this should constitute a legal life interest which can be registered, because when this is actually registered, the actually separate title deed is issued for this property, right? One for the life and one for the remaining one after the person passes away.
Great.
This is one of the things that we face when we deal with conveyancing. Also very much similar to divorce cases where the court order is not clear. Essentially, this is where the complication will start to arise lah.
Right.
Yeah.
Right. Which brings us to the next question, because nowadays over the past few years, decoupling has been so popular, right? And not just decoupling. Couples are buying a property under each name because everybody wants to avoid having to pay the additional buyer stamp duty if both couples have buying power. Decoupling or buying one under each name is natural route, right? And how has been the trend like when it comes to decoupling or buying a property under each name?
Most of the time, what we see is that couples, after they decouple or they actually own separate properties, most of the time they will actually will it to the surviving spouse first, everything. And only if, let's say, the surviving spouse doesn't or passes on lah, in the event the surviving or the spouse actually passes on before them, then it will actually go to the children. So this is something that I think is quite common.
So you're saying like interwilling kind of practice lah.
Correct.
Okay. How about in the event if let's say there's a divorce?
For divorces instituted in Singapore, there's this concept of matrimonial property. Even though legally the properties are owned under the respective the husband's name or the wife's name, where this property is acquired after the marriage, or where it is acquired before the marriage but there was substantial improvements made to the property, it can actually be considered as matrimonial asset. Right? So when it is considered as matrimonial asset, then the court will have jurisdiction to actually redistribute the property. So some of the things that we have actually seen, either the property either remains in their own name, or that sometimes they will do an exchange of the properties, especially when they have both their names on both properties lah. In those situations, then they will divide it in such a way that one person will end up with one property. But if they are already separated, then usually it can be
counted as
it will be counted as the matrimonial asset. pool.
In total.
In total.
Okay.
So the court will have a right to actually divide the property, right? And in the recent years, there's this a lot of the divorce orders are consent orders.
What is the consent order?
Consent order essentially means that both parties agree to have the distribution of asset, and this agreement is filed as a court order, right? So essentially, it makes the divorce more straightforward, right? Because they've already agreed to it, and they don't have to contest it in front of the court. And the court generally, if there's no major issues with it, they will generally agree and they will seal on it. So it has the force of a court order, but essentially the agreement behind the distribution has already been consented by both parties, right? So consent order makes it easier to deal with the conveyance. So if anything is requires some clarification, then we'll just go back to the parties to ask them to clarify what was their actual agreement at the point of time. So this is to assist with their distribution obligations to make sure that the conveyance is done correctly. Yeah.
Great. We have done the topic on buying properties under trust in season 1 with another guest that appeared on the show. But just to bring back the purchasing under trust kind of concept, do you see it rising over the past year? Because definitely over the past few years it has been a very popular practice buying. I mean, but this is of course pertaining to only families that can fully pay a property, because when you buy trust, you can't take a mortgage on it. So maybe just to bring back that topic, has there been any changes to the trust law buying properties under children that's below 21 years old over this past 1 to 2 years?
Over the past 1 to 2 years, I don't think trust law has actually developed a lot or changed a lot in respect to purchasing real estate on trust for minors. The law has actually stayed the same, but I think there is an increase in the demand to have properties actually purchased or structured under a trust situation. So trust device is something that is requires consideration, proper consideration, because there are many legal obligations that is being tagged to this trust device, right? So briefly, essentially, a trust is set up, right, when there is a trust deed, and the terms of the trust deed essentially creates this legal concept called a trust lah. So how should we think of it, of the trust? Essentially is that we should think of a trust as a person who is holding there are two parties who are holding different sets of legal interests over that asset, right? So a little bit technical, but the concept essentially is that there are these two different concepts in law. One is called the legal title, right, and one is called a beneficial title, right? So the legal title is usually held by the person called the trustee, and the beneficial ownership is held by the beneficiary. Most of the time in Singapore context will be the kid that's below 21 lah. Yeah, so there's a difference in this obligation, and between the beneficial owner, which is the children, and the parent, who is the trustee, there's a set of legal obligation and duties that the trustee need to follow in discharging the management of the property under the trust concept or the trust creation. So I think many people use it as a device to avoid additional buyer stamp duty. But there are also implications, because these implications will not surface until many years down the road.
Maybe what are some of the implications that
some of these implications essentially is that the first one is that the property count is counted as the beneficiary's property count for ABSD purposes, right? So in the future, when this kid actually turns 21 or is of age already, they want to buy a property, and if they do not know that they have a property under trust in their name, they are going to be hit with ABSD for their so-called first property purchase, right? So it is it is important that if the property has not been sold by the time the beneficiary decides to buy another residential property in Singapore, then the beneficiary needs to know that he has this property, even though the title deed doesn't show his name. This property is beneficially his, right? Because the property count for tax purposes actually shifts. So when he buys his own property under his own name, he will actually be hit with additional buyer stamp duty. So this consideration is something that needs to be kept in mind, because it will only come into play many years down the road.
Years.
Yeah, when the kid actually turns 21 and he can actually buy his own property. So one of the other situation that I can also think of is if the kid wants to buy a BTO, he has a private property, he's supposed to dispose it 30 months before he can apply for BTO. And he realizes at the point of application that he cannot make the application because he has a private property. So these are things that you need to keep in mind, as long as a person who wants to purchase a trust property understands all these risks that they are creating and undertaking, and very much involuntarily for the beneficiary, because the beneficiary has no control, then it's definitely fine. But they must understand that these things can happen and it may end up being a very big dispute down the road.
Right.
Yeah.
Right. How many years does the trustee have to hold the property before they can sell it?
For seller stamp duty purposes, currently is 3 years lah, right? But this trust concept, it's a legal concept. So whether there are any restrictions on the trustee's ability or power to sell the property can also be found in the trust deed, right? So if this is a very detailed trust deed that has special restrictions saying that this is a property trust, but the trustee is not entitled to sell the property, right? Then the trustee will not have power to sell the property, right? So in terms of seller stamp duty, we know that for now it's 3 years, yeah. But when everything is under trust, a lot of it, how to manage the property and what the trustee can do with the property, actually we always need to look back at the trust deed itself.
Who decides what's in the trust deed?
Usually the trust deed will be drafted by a lawyer, and it depends on what perspectives and what do you want inside the trust deed. So most people, when they enter into a trust device, their main concern is about additional buyer stamp duty, which by right it shouldn't be lah. Okay, because the trust
That's
concept,
not the main purpose.
the main purpose of a trust concept in general law essentially,
It's like a gift for the minor.
it's actually to allow the management of the property to be done by the trustee for the benefit of the beneficiary.
Until 21.
Yes, until 21. So trust can also be set up even if the beneficiary is not below 21. Yeah, it can be done, right? A trust
It can
concept.
be done for an adult.
It can be done for adult. It can be done for charitable purposes, right? For example, if you want to create a trust so that maybe your disabled child who is above 21, you are afraid that he is not able to manage the finances properly by himself, right? You can set up a trust. The trustee essentially is the person who is holding the legal ownership, but must manage the property for the benefit of the beneficiary. So he cannot do anything that would generally be detrimental to the beneficiary. So this is the kind of a legal relationship that we have in a trust. So the trust device is very useful in many areas, but for real estate, right, most people think of it as a way to avoid ABSD. Yeah, so but that generally shouldn't be the main concern.
It shouldn't be the main intent in the sense.
That shouldn't be. Yeah.
Okay. It's just that it became popular.
It became popular because ABSD is very high. So whatever device that people can get their hands on, they will want to try it.
Sure.
Yeah.
Okay. Thanks for sharing on the trust portion. Let's move on a little bit to the purchasing and selling kind of minute details. Right? So recently the past especially the past 24 months, there has been a very common practice because the market is moving very fast. Right? So market is moving fast. With the restrictions of COVID, the amount of viewing into the property physically is also being affected. Like, especially for properties that are very popular. We talk about a lot during our Nuggets on the Go, the other podcast that we talk about the market conditions right now. Is that landed properties are extremely hot. Large size apartments very popular right now. I think there's been like a change and shift in sort of like our preferences for a home, especially after the circuit breaker and all that. People are all looking for bigger properties and more space. Yeah, which is also why like penthouses, ground floors are getting very popular as well. So people want to have a combination of outdoor, indoor, or maybe just an additional bedroom to use it as a home office, right? Or for their kids.
Right.
So because of this, when it is in the uptrend market, it's also very common that a lot of home sellers right now that wants to purchase their next property is a natural instinct. Let's say, for example, if I'm looking for a home, I would want to sort of see what is out there in the market first. So I want to hunt for a property, and by the time maybe I have viewed like 20 properties, I finally found the one I like. Then I realized that, hey, I haven't sold my place yet, and if I were to put in an option, I'll be taxed with the ABSD. I cannot get the full 75% loan, all that kind of stuff. And then if I were to come back and then focus on selling, by the time that property might be gone. So this is always the dilemma in the uptrend market.
Right.
So which gave rise to, of course, the practice of putting in a higher option fee, plus negotiating with the next home current seller for a longer option period. Right. So of course this 24 months, past 24 months, this has been pretty common. I mean, a lot of negotiations, options are drafted with a longer option period. So maybe you can share with us like what are some of the things you see on the ground from your perspective as a convincing lawyer.
Most people or most buyers in Singapore know for a fact that when they actually grant an option with a longer option period, I think they have already been advised many times that they are undertaking the risk and
As a seller.
Yeah, as a seller, that they are not able to resell this property to anybody else until the option that they have granted has expired. So on the ground, we actually don't see that many cases where the sellers want to back out. I think most of them know that
honor the contract.
They have to honor the contract, and that if they want to back out, they will either have to get into a very complicated dispute with the buyer. If not, then they may have to even fork out more money to convince the buyer to give up the option, which then may not be good for them. Yeah, so on the ground we actually don't see that many cases, but for the issue with the grant of a longer option period, I think it's something that it's very common, and I think it has been used quite well. Just that the sellers are taking this business risk on themselves, which is usually why when there's a longer option period, the option fee will also be higher. So this is essentially to compensate them.
Right. Both parties partake in the risk in a sense.
Yeah, correct. So on the ground we don't really see that many cases. Most of the time, even if we do hear where our clients as sellers who want to toy with the idea of trying to back out, after they hear the repercussions, they usually will just wait it out.
Sure.
Yeah.
What if the seller backs out? Like maybe it's a 3 months option period, and after 1 month the seller has remorse, seller decides to back out. What are the legal implications that, or what recourse does the buyer have to take against the seller?
For the buyer side, of course, the first starting point we will always tell the clients essentially is that you will have to firstly negotiate for the cancellation of the option, right? And then we will see whether the terms of the cancellation is something that you would be able to undertake. I mean, there are also buyers who are nice enough to say that, okay, it's fine, we can cancel and then we can just do a refund of the option fee, and then both parties go their own way, right? So it's the first step is always to enter into negotiations. But if the buyer is not willing, because the buyer really loves the house and needs and wants to exercise, but he's waiting to sell his existing property first, then essentially this will be considered as a repudiation of the contract by the seller, right? So when it's repudiated, essentially meaning that the seller is telling the buyer upfront that I don't intend to sell you this property anymore, and I want to back out. So the worst case scenario essentially is that because it's still within the option period, the buyer can actually go to court to ask for specific performance. So specific performance essentially is a remedy where the court would order that the transaction is to continue to proceed, and that will also mean that the seller will be forced to sell and to transfer the property to the buyers. So that will actually mean that makes no difference lah, because he will still lose his house, right? And then of course the sale proceeds will come in. He still gets the sale proceeds. So this is the worst case or the worst case scenario that can actually happen. If not, then the buyers either will ask for additional compensation in order to
Settle amicably or something.
settle amicably to cancel the option,
Right.
or that they can actually ask for damages, right? So if any loss has been incurred on the buyer side, then that can also be actually
Negotiated.
claimed against the seller, right?
How long is the process to apply for specific performance?
Specific performance nowadays, I think the application to court is not very common.
Oh,
Yeah, it's not is not very common because the whole process is long. It's essentially a litigation case, right?
So let's say the seller backs out, buyer really wants a house, and they want this thing to go through. How long does this whole thing take, like, to go to court and things like that? Does it take a year or?
It could take up to a year, depending on how much evidence you need to put forth to convince the court to grant this, to grant this remedy and specific performance. Of course, if you have a lawyer that is expediting the case, it could of course be done in a couple of months.
Right.
But the I think one of the reasons probably why there aren't so many cases of
So
specific
most people honor
performance.
the contract.
Well, most people honor the contract, but also it's quite expensive to go to court.
Right.
That's
but,
the first
but
thing.
What if at the end the buyer wins the case? I mean, because they have paid the option fee, the option has been granted. Is a willing buyer, willing seller thing at the initial point, but seller decides to back out 2 months later. And let's say after a 6 months court proceeding and things, and the buyer wins it, can the buyer claim damages in terms of like the delay in the completion and then the legal fees and things like that? Like, usually how is it done?
For the court application itself, usually if the buyer actually wins, then it is quite likely that the court will probably order that the costs will be paid to the buyer, right? So damages for the delay in completion, all these things will have to be asked for. And one of the reasons is because specific performance is not what we usually call as granted as of right lah. Essentially means that if you apply to court and then you fulfill certain conditions, then definitely you will get it. It's not something that is so straightforward that the court will order. The court will actually have to look at various circumstances and decide whether they think it's fair to actually grant this remedy, because this remedy is, as the court mentions, usually they'll consider it as quite onerous, right? So if, for example, if damages or payment of compensation monies by the seller to the buyer is sufficient to compensate the buyer for whatever losses that he has incurred, right, because of the withdrawal of the option by the sellers, then in this case, you may not be able to get specific performance. So you may be able to get damages money, but you may not get a house lah.
Oh,
Yeah,
okay.
correct. So the issue with this particular remedy is that you can spend all the court fees to go to court, but you may not get what you want at the end of the day. You might end up having just money and not the house. So sometimes after people assessing the risk, they'll say that I don't want to waste my time lah.
Okay.
Yeah.
Understand. How about, let's flip over to the other side. Let's say, example, the buyer plays in the option fee, and then 2 days later, seller wants to bang in, and then check bounce. Right. Then option has been granted. Let's say it's option granted, check exchange on the same day. 2 days later, check bounce, buyer MIA. right? And what's going to happen here? What kind of recourse can the seller take?
Essentially can claim for the option fee, right? Most likely can claim for the option fee because at this particular point in time, it's a little bit different from the first scenario, right? Because in this particular case, whatever that the seller has on hand, essentially, he's only entitled to forfeit the option monies
Correct.
if the buyer doesn't exercise, right? So in this case where the buyer actually hands over the option fee by bound, so it didn't clear, we do not know whether the buyer will actually exercise. So if there's anything to be claimed, essentially the losses that will be incurred by the seller would be the fact that he did not receive the money that he was entitled to forfeit lah, which is usually the option fee. So that would generally be the amount that he would be able to
how
claim.
is the seller going to claim this amount? I mean, will let the law firm do the job to locate the buyer, or
I don't think the law firm will be able to locate the buyer if the buyer hasn't even contacted their law firm. Right.
like through the IC number, the full name that's listed on the OTP, like what is the next step of action?
So in this case, if you really want to claim for it, you will have to initiate court proceedings, which may or may not be cost effective to recover the
How much will it
option
cost?
fee.
Like,
I think essentially, when you actually apply to court, definitely legal fees will be at least a couple of thousands already. So depending on how big the option fee is lah, whether you want to go through the trouble of going through the whole court proceedings. So and for court proceedings to actually start, you will have to notify the buyer that you have initiated court proceedings on him. So if he has really physically gone MIA and even the agents, the lawyers, nobody can find him, then there will be some difficulty in initiating the court proceedings. That's the first hurdle.
okay.
The second hurdle essentially, of course, will be that there's something called substituted service lah in all these court proceedings things. Means that even if you cannot find the person, you have other means of trying to so-called serve the notice.
Okay.
Right, even if you cannot personally find them.
Okay.
But all this will mean additional costs. So it's a cost benefit
You can
analysis.
serve at the workplace and things like that.
Yeah, sometimes I think recently service on WhatsApp, I believe Facebook has also been acknowledged by the courts. Yeah, but you will need the court approval to allow you to do it digitally lah.
Wow. Okay.
Yeah.
What if the buyer didn't MIA and the buyer says that they just don't want to pay. They stop the check. They don't want to pay. Even though it's stated, I mean, by the law conditions 2012 that OTP granted, check issued. This is a legitimate transaction, and you have to fulfill the covenant of the check and making good of the check. So what if the buyer just after 2 days, 3 days, just say, oh no, I just stop it. I don't want to proceed. I don't want to continue. And seller, they will continue to serve court proceeding if they want to, like if they weigh the cost.
Correct. If they want to.
Should they serve it after the option expire, or should they serve it during the option? What is the obligation? Because just for example, if it's a 14-day option period, the buyer can come back on the 14th day and say, hey, why do you serve me a court proceeding? I want to exercise. Okay, I'll make it a 1%, then I'll continue to exercise. Right. So but what if it's like a 3 months option, and can a buyer come back later, after the court proceeding has been served during the option period, and say that, I still have the option with me. It's just that I never make good the 1%, or maybe I didn't make good the 2%. Now I want to make good all 5% together to exercise the option. Like what is? I mean, this is a bit sensitive in this case. What should be done by the seller?
For this kind of scenario, I think it's not extremely clear what is the best way forward. But I think most of the time what you would want to do is if you really want to initiate court proceedings, then I think you should be able to initiate them as early as possible, right? Because I think it would be clear to say that I think most options also state that it is in consideration of the monies. So if the monies has not cleared, right, then the seller could very well say that the option was not properly granted, and even if you wanted to exercise, you couldn't. So, because the money hasn't come into my hand, the option is not considered as properly granted for you to exercise, right? Even though we know that most of the time it's exchange for the cheque, right? So in this case, there are many ways it can actually go. But if you really want to initiate the court proceedings, then it should be as early as possible, because then you should rely
It's not to wait.
it's to rely on the fact that and to make it very clear that the option is only granted properly, and the offer will only be held out for the 3 months, right, for the buyer to exercise if the
Option money is
option money has been properly paid. Yeah.
Okay, great. Let's move on to this part of a buyer successfully purchase a landed property. I mean, the past 1 year, landed property has also been very hot. So, for example, let's say if somebody were to purchase a landed property and they want to go through a process of A&A or reconstruction, and then halfway into the process, something happened during the reconstruction phase or rebuild process, or maybe A&A phase, and then there's been some damages to the neighbor's property. Yeah, especially if it's like an inter-terrace, the side walls are all shared with the left and right neighbor. So, and then and let's say the neighbor decides to claim damages and sue the owner. What is the responsibility route over here? Like, who is responsible? Because from the owner's point of view, from the buyer's point of view, who is the new owner now of this property, they have engaged a builder or contractor to renovate A&A, rebuild, right? So when the neighbor want to sue, is to sue the contractor or to sue the owner? Like what is that relationship over here?
I think most of the time, the neighbor will sue everybody lah.
Okay.
Right, because usually when you start a suit, you will sue, you'll probably sue both the contractor as well as the owner, right? So that they see who is found liable and then who will pay lah, right? Because generally only these two parties are involved, right? So the relationship here is not one of contract, because there's no contract between the contractor, and there's no contract between the owner as well as the neighbor. So this is essentially what we would consider as most likely a negligent suit. So this is a tort suit. So essentially, negligent is something that is a duty from the owner to the neighbor, and a duty from the contractor to the neighbor, right? So depending on what is their relationship, and depending on whether the owner and whether the contractor that's being employed by the owner has actually fulfilled their duty of care. So this duty of care is the legal standard, essentially, that the court will have a look at all the evidence, and they will see whether the parties have been negligent. So most likely it's going to be these kind of cases. If the parties have not been negligent and they have actually complied with whatever that the law requires them to do in terms of for the owner, most of this will of course be contractor or subcontractor. They are not direct employees of the owner, right? So whether the owner has actually contracted for a contractor who has the licenses and the experience to do the kind of work that he has employed the contractor to do, and when the contractor actually carries out the A&A on the construction of the property, whether they have complied with the reasonable standard in actually doing their construction work for the particular owner. So if they have actually met with this legal standard, right, essentially what we call the duty of care, then there will be no legal obligation for the owner as well as the contractor to have to compensate the neighbor for damages to their property. Yeah, generally that wouldn't be. But of course, if the contractor had been negligent, he didn't correctly protect the wall before he did the hacking, right? Then the court found that this is not the standard that has been met legally. Then yes, probably they might have to pay the neighbor for the damages that has been incurred on their property.
In the relation of the owner with the builder, what kind of duty or care relationship does the owner and the builder need to have? Does the builder have to compensate themselves, or the owner have to compensate? Because it was the owner that employed the builder, right? So what is that kind of relationship there?
Okay, so the relationship, as I mentioned earlier on, the neighbor will probably sue both
Everybody.
the owner and the contractor,
Yeah.
right? So the damage was suffered on the neighbor side. So the relationship that the court will be looking at is between the owner and the neighbor, as well as the contractor and the neighbor. So most of the time, I don't think the owner will be found negligent. Okay, because I think contractors all have their license, and then if you give them this piece of work to do, if they don't have the experience or the license to do it, they shouldn't have accepted it. If they accept it, generally that will also mean that they have the expertise to be able to do it properly. So most likely, I don't think the owners will be involved. So maybe it will be the contractor who would have to pay directly to compensate the neighbor. Right. So if the contractor has to compensate the neighbor directly, then there will be no loss to the owner lah. So the contractor doesn't have to pay anything to the owner because there's no loss to the owner. Right. Maybe save for legal costs lah, I suppose. But let's say if for some odd reason the owner is the one that is found to have to compensate the neighbor, right? It's possible that the relationship between the owner and the contractor is not really one of negligence. Most likely you will go for the contract, because they have a contract for the construction works to be done. So in the contract, we will have to look into the contract and see if there are such things that happen, what is the contractor's obligation to indemnify or to reimburse the owner for the losses that's been incurred.
Right.
Yeah.
Okay, great. Yeah, I think we have talked about 5 broad topics today. So I think the very first thing we'll talk about today was about inheritance. And then that move on to some common questions when it comes to divorce. And then we talk about trust, and then on the option money, as well as some recourse between seller and buyer. And then of course lastly will be some renovation kind of guidelines when to avoid any form of disputes and things like that. I think it has been very insightful with Ivan with us from Tito Isaac and Company. And maybe Ivan, just to end off, is there any advice you want to give to our audience when it comes to maybe just on one point that you want our audience to take away when it comes to buying a property right now in the current market?
The main point essentially when you are transacting real estate is the issue of getting the option correct. So the option essentially will be the contract governing the relationship between the buyer and the seller, and how the ownership is to be transferred to the buyer at the end of the day. So in this current market, I think there are a lot of situations where people want to take early possession, they want to change completion date because they always have another pending transaction that they will need to time. All these things needs to be considered carefully before they even enter into the particular option. Right, so the reason why I say this is because regarding completion timings, regarding early possession, regarding early completion, or all these things should be negotiated before the option is granted, because once the option is granted on the terms as it should have been granted as per the agreement between the parties, the contract for the sale and purchase of the property can only form if there is no variation to the option, right? Because in law, the acceptance to the offer must be unconditional. So you cannot say that, okay, I agree to buy your property, but then I want to add A, B, C, D, E, right? So that doesn't form a proper acceptance, and that doesn't form a proper contract. So all these things I think needs to be negotiated, and if they are not found in the option, they should be drafted into the option. right? I know in market practice because the options a lot of times are granted very quickly. So there isn't sufficient time for a professional to look through the terms and to incorporate what other considerations that require. And then they start asking for additional documents like, oh, can we have a tenancy later on? Can we do the letter of indemnity later on? But all these things are not part of the contract, right? So if you actually negotiate for it, then you should try to get it into the option, because that is where your foundation of your legal obligation is. So if it's inside there, which means that you can be ensured that it will be performed in the manner that you have agreed. But if you discuss it verbally and you don't put it inside, and most options also have an entire agreement clause, meaning that all the terms and conditions of this transaction is found inside. Right, so this I think should be the main takeaway, given that this market is a little bit different from the past years, and there are a lot of back-to-back transactions. So all these considerations, it should be discussed, and once it's discussed, should be put inside the option. So we do not actually end up in a dispute down the road. Right, and then we will have to ask, but you said this, then we will say, but it's not here, so it's not enforceable. Now we will have to end up doing a request. And when we do a request, you may not get what you want at the end of the day. So it's best to have everything in the contract so that you know that you have something to fall back on, and everybody knows what their obligations are.
Great. Thanks for the advice. I think that's very important, because everybody wants a happy purchase and sales experience, and nobody wants to get into unnecessary litigation and to make this an unpleasant experience. So buying a home is a happy event. Selling a property should also be a happy event, because when you sell, you are definitely going to your next home if it's your primary residence. So thank you, Ivan, for taking time to come to our studio. For So Far So Good season number 2. And if you want to locate Ivan, we'll put in his details, contact details of him and his firm right down in the description, link down below. And of course, if you want to reach him, you can reach him via email or via his contact number, and I think he'll be very happy to assist you together with his associate. So thank you once again, and of course thank you for watching So Far So Good with Propertylimbrothers. We hope to see you on the next episode. Meantime, take care.
That period of his life, which means that nobody knows when he's going to.
But is he allowed to sell in the first place? Because